court is taking up the case of Michael J. Diller, plaintiff, versus Jefferson County, Nebraska Board of Commissioners of Jefferson County, Nebraska, and Arthur Craig Jr., Michael Dukes, and Marvin Yost in their official capacity as Jefferson County Commissioners, CI 12-152. And hearing is being held today on both parties for motions for summary judgment. And of course, motions for summary judgment are dealt with by evidence consisting of affidavits, depositions, and or pleadings on file. And the record will reflect the appearance of Mr. Joseph Casson, attorney for plaintiff, and Mr. Daniel Werner, attorney for defendants. And then also there are parties present. And just for the record, Mr. Casson, I would ask you to introduce who you have with you at council table.
Your Honor, seated with me is Michael Diller, the plaintiff in this section.
And Mr. Werner.
Your Honor, Michael Dukes, one of the commissioners of Jefferson County.
All right, very well. The record will so reflect. A couple of preliminary matters that the court will take up first. I'm aware that FebruaryNews.com and channel 1011 is video taping the proceedings today. This court does have a rule for expanded media coverage allowing that. Normally there is a notice given by the media on a form prescribed that's on the Nebraska Judicial Branch website 14 days ahead, which gives counsel an opportunity to make objections and then for the court to have a hearing if there are any objections. I understand, however, from conferring with counsel that there is no objection, and accordingly then those news media entities are allowed to record the proceedings. And Mr. Casson, let me ask you if that is correct, that is your stipulation.
Yes.
And Mr. Werner, is that correct for your stipulation? Thank you. And Mr. Werner has filed a statement of objection to an affidavit that's going to be offered by Mr. Casson, an affidavit of Michael J. Diller. It consists of several pages, and I've discussed that with counsel. And what I'd like to do is, rather than take the time today to go through each objection and hear argument on each objection, I would take that statement of objection under advisement. Any affidavit by Mr. Diller would be received subject to the court specifically ruling on Mr. Werner's objections. And if to the extent, Mr. Casson, you may want to make any written response, I would give you an opportunity to do that. And then I've also discussed with counsel that I would rule on the statement of objections in writing after I've had a chance to review that and consider any arguments. And then counsel, in addition to making oral argument today, would like to submit briefs and would be given 3 weeks after the ruling on the objections to submit briefs to me. And then both sides would also then thereafter have 1 week for an optional rebuttal brief. And then the motions for summary judgment following the time for briefing would be under advisement. I would get you a written ruling as soon as possible. Mr. Casson, is that your understanding?
Yes, sir.
And Mr. Werner?
Yes, sir.
Mr. Casson, do you know at this time if you want to make any, or have an opportunity to make any written response to Mr. Werner's objections to Mr. Diller's affidavit?
I believe I can address those today.
All right. Very well. And we'll proceed, of course, first with the receipt of evidence and then the arguments of counsel. Are there any other preliminary matters that we need to deal with?
No, Your Honor.
If anyone thinks of any evidentiary showing, and I'm going to assume that you're going to offer your evidence with respect to both motions for summary judgment.
Yes.
Mr. Casson, and same thing for you, Mr. Werner. Mr. Casson, you may proceed.
Thank you. Your Honor, I would offer Exhibit 1, which is the affidavit of my client, Michael Diller, consists of various exhibits, and I understand there are objections to the same to address those at the appropriate time.
I would renew my written objections to the affidavit.
All right, I'll receive Exhibit 1, but I'll also take judicial notice of the statement of objection to the affidavit of Michael J. Diller, which is Exhibit 1. And Exhibit 1 then is received subject to the court ruling on those objections. Any other evidence from plaintiff, Mr. Casson?
Your Honor, with regard to additional evidence, the objections to the affidavit submitted in Exhibit 1 fall into generally two categories. One is essentially hearsay statements by my client addressing certain issues in the lawsuit which may be considered conclusions of law or beyond his personal knowledge. The court, of course, is able to separate out any such items and would not consider them as evidence. The other portion of the objection relates to the foundation for the exhibits which are attached to the affidavit, which primarily consists of documents which are of public record on file in the Register of Deeds office. What my client has done is attach to his affidavit copies indicating that they are true, correct copies of the original. In addition, there are 3 depositions which were taken in a companion case for which copies have been provided to the court. The defendants have objected to those exhibits from the Register of Deeds as not being certified copies, that the depositions from the companion case not being certified by the court reporter, they simply being copies which have been provided to me by the other attorney in the other case. That what I would ask with regard to that is if the court rules that the copies which are included in my affidavit are not to be considered because they are not certified copies, I would ask leave to leave the record open so that certified copies of the documents in question can be provided, as well as depositions in certified form which are in the possession of the counsel in the companion case. Other than that, I have no other evidence.
All right, Mr. Werner?
Your Honor, I do feel constrained to amplify on my objections that I have filed. As I'm sure the court is aware, that affidavits are not merely admissible because they are affidavits on a motion for summary judgment. They have to show foundation. They have to show the ability to testify in court to the facts that are stated. And if that is not shown, if the client is not competent to make those statements, then those statements do not come in. Of course, opinion, beliefs of Mr. Diller are not to come in, and conclusions of Mr. Diller are not to come in or be admitted, and conclusions of law are the prerogative of the court, not Mr. Diller. And the affidavit of the plaintiff is full of conclusions, of statements of belief, of conclusions of law, of things that he is not competent to testify about. And I would like to go through them if I might. Some are more important than others. In paragraph 4 of the affidavit, he refers to the county commissioners of Jefferson County having the authority over bridges, public roads and highways in Jefferson County. That may be true as far as it goes, but if you added which are owned by the county, it would be correct. It is not correct the way it's stated, and for that reason, it's an incorrect statement of law, and I object to it. Similarly, in paragraph 6 of the affidavit, Mr. Diller refers to public roads and public bridges, and I assume that he is making that statement intentionally so that the court assumes that that road is public and therefore within the jurisdiction of the county. And that is not true. And that's why I object to that as stated in the objections. The things that are shown as attached exhibits that are objected to are apparently records of the county clerk register of deeds that are not certified. And Mr. Diller is not an abstractor, and I don't know that they are complete and correct copies of the record. And because he is not an abstractor, because he is not a certifying official, those would not come in a trial by his testimony. Since they don't come in by trial, he is not competent to testify about them. There is no foundation that shows that he is capable of verifying or authenticating a record from the county clerk's office that he may or may not have found. And so the court should not accept that. Now, I think it is error for the court to hold the record open. The law is that the documents must be submitted to the other side 10 days in advance of the hearing. The hearing is today. And so if they have not been submitted, and I did not receive these depositions or copies of them, and I'm not sure the council had them before today, but I assume that they are not certified by a court reporter. If they are not certified by a court reporter as accurate, Mr. Diller cannot certify them to be accurate copies. There's no showing that he was present during those depositions, and the court could not receive them in evidence based on his testimony because he is not competent to testify. And so there are a lot of the records that I did not object to because, quite frankly, I'm going to put them in anyway. But the copies that are copies of subdivision group plat, I've seen the subdivision. It's huge. It's 3 to 4 foot wide and 3 foot tall. And these are an 8.5 by 11 paper. I'm not sure that they're complete. I doubt that they're complete. And that's just not admissible. And to allow the submission of additional affidavits following the hearing, I think is contrary to the law on the motion for summary judgment. There are various things in the affidavit. For instance, the road is one of the same on the attachments, is one and the same as the road known as Farmstead Road. There is no showing that Mr. Diller is competent to testify about that. He is not an engineer. He is not a civil engineer. He's not a surveyor, as far as I know, and there's nothing in the affidavit that shows that there's personal knowledge to those kinds of facts. And it goes on to say that the United States of America retained no interest whatsoever in that road. And I say to the court that I will argue that in a little bit, but it's contrary to their own evidence. And it's contrary to the evidence that I will submit to the court on defendant's motion for summary judgment. And actually, these affidavits were noticed in exhibits 5, 6, seven, 8, and 9 as affidavits in opposition to Mr. Diller's motion for summary judgment and in support of defendant's motion for summary judgment, so that it would be appropriate for me to offer those exhibits at this time in opposition to the motion for summary judgment, but I will await that if the court please. But I do intend to offer them as exhibits in opposition to Diller's motion for summary judgment. And so, for that reason, I would offer exhibits 5 through 9.
All right, Mr. Casson, does that conclude your offer at this point, Exhibit 1?
Yes. With the request to leave the record open.
All right, I note that request, and I'll deal with it later. Mr. Werner, then you may proceed with your offer.
Offer exhibits 5 through 9 in opposition to plaintiff's motion for summary judgment.
All right, defendant offers exhibits 5 through 9. Now, when you say in opposition to the plaintiff's motion for summary judgment, is that also in support of
It is
our
also
motion for summary
in support
judgment?
of my motion for summary judgment, Your Honor. I thought that we might take them up separately, but there's no reason not to offer them for both purposes.
Any objection, Mr. Casson?
No, Your Honor.
All right, exhibits 5 through 9 are received.
And, Your Honor, I didn't mean to stop my argument.
No, I understand. I'm just dealing with the evidence at this juncture. Mr. Casson, I'm willing to do this as far as holding the record open. It appears that Mr. Werner is objecting, as he's entitled to do, to Register of Deeds records that aren't certified and depositions that aren't certified, and I would have to sustain those objections unless there was an agreement by the parties that I could consider them without those certifications, and obviously there's no such agreement. So what I will do, if you wish, Mr. Casson, is hold the record open, and I'll set another date for evidence to be presented, and that would give you an opportunity to present certified copies and also to provide copies to Mr. Werner. But in that regard, I would give both parties an opportunity at that next hearing to offer additional evidence, and unless there's a stipulation to the contrary, of course, copies would have to be exchanged at least 10 days prior. So, Mr. Casson, would you like that opportunity?
Yes.
All right, we'll go off. Yes.
I renew my objection.
Yes, and I understand you object to that, so I'll overrule that, and we'll go off the record and check with the bailiff and the council for a date for further evidentiary hearing.
Do we want to do the May 2nd? I don't know if we have to have 10 days prior notice. I don't know that April 18th is going to be enough.
No, that won't be